Welcome to The Explainer. Today, we're diving headfirst into the often overwhelming world of Ohio estate planning. Look, if you've ever felt, completely lost in a sea of legal jargon, just take a breath. We're going to clear it all up right now. We'll be demystifying the 18-month probate process, plus the whole complex business of real estate liquidation. And we're pulling insights directly from expert Ohio legal sources to make this absolutely 100% accessible for you. Okay, let's just dive right into the roadmap. We're going to start with planning your Ohio estate, then we'll look at entering the probate process, followed by selling a probate property. After that, we'll meet the 5 key players involved, and finally, answer the absolute biggest question: who pays the bill? So, let's get into it.
First up, Section 1, Planning Your Ohio Estate.
Now, when you're getting proactive with your assets, there's a really vital distinction that honestly catches a lot of people off guard, and that's the difference between a will and a trust. Basically, a will identifies your assets and names your heirs, but, and here's the kicker, it must go through the probate court. A trust, on the other hand, is a completely separate legal entity. It holds and manages your property and completely bypasses the probate process. So if your goal is to keep your family out of the courtroom entirely, a trust is for sure your best tool.
According to Ohio attorneys, a rock-solid estate plan relies on 4 main pillars. First up, writing a will to officially name your heirs and an executor. Second, creating powers of attorney. This authorizes someone you really trust to handle your financial or life matters while you're still alive. Third, setting up those trusts we just talked about. And fourth, creating advance directives for your specific healthcare wishes like DNR orders. Actually, getting these proactive documents in place is literally your absolute best defense against chaos if you were to become incapacitated or pass away.
Moving on to Section 2, entering the probate process.
So, you might be wondering, what actually forces a family into the probate system in the first place? Well, probate is explicitly triggered when a titled asset, like a bank account, a piece of property, or a vehicle, is left solely in a deceased person's name without a designated beneficiary. So if there's no legally named beneficiary attached to that specific asset, the state basically has no choice but to step in and oversee how it gets distributed. And let me tell you, the probate lifecycle is a marathon, not a sprint. Month 1 is pretty much consumed by filing all the necessary paperwork and validating the will. Then, months 2 and 3 involve formally notifying all the heirs and creditors. And then, months 4 through 17 get incredibly heavy. We're talking valuing property, paying estate taxes, settling bills, the whole shebang. Because of all this, you likely won't see any remaining assets distributed until month 18 or even later. It is a massive waiting game.
Now, if hearing 18-month timeline makes your blood pressure spike, you definitely aren't alone. But I want you to listen to this quote from Sandra O., a client who went through this exact process in Ohio. She noted that her attorney answered all their questions and guided them in the correct direction, saying, "I have more peace of mind about our assets now than before." Sandra's experience is just proof that, with the right legal guidance, the heavy, confusing burden of probate can absolutely be replaced with complete peace of mind.
Which brings us to Section 3, selling a probate property.
Okay, first things first, we have to clear up a really big misunderstanding here. A lot of people just assume, oh, the heirs can just sell the house immediately and split the money. I cannot stress this enough. In Ohio, there's no way that's allowed. Heirs cannot legally sell a house, or honestly even list it, until the estate is officially opened and the court grants the specific legal authority to do so. So let's walk through how this actually flows. It starts with filing the will with the probate court, which then allows the court to officially appoint the executor. Only after that happens can the attorney formally open the estate file. Finally, with that legal authority in hand, the house can be maintained and listed on the market. Once a buyer's offer comes in, the executor and the attorney meticulously review it. So you see, the property is prepped, listed, and negotiated under strict legal supervision the entire time. But here is the absolutely crucial point. What happens next? Once court approval of the sale is secured, if it's required, a title company handles the closing. But here's the catch. The sale proceeds strictly enter an estate account. From there, attorney fees and outstanding debts are paid off. Only after those debts are cleared is the remaining money finally distributed to the heirs, which allows the estate to officially close. So basically, the money has to detour through the estate first to clear debts before a single penny reaches the family. All right, Section 4, the 5 key players. Right at the top of the chain, we have the court. In our sources, this is specifically referring to the Logan County Probate Court.
You can think of them as the ultimate authority and referee. They open the case, validate the will, appoint the executor, and basically make sure taxes and final distributions are handled perfectly. They provide the oversight, but they aren't, managing the house day to day.
That day-to-day heavy lifting, well, that falls to the executor. They are the hands-on manager of the entire operation. They're the ones filing the will, gathering assets, maintaining the physical property, and signing the listing paperwork. But remember, they still need that court authority we just talked about to actually finalize any real estate sale. Now, to keep the executor out of legal trouble, we bring in the probate attorney. Acting as the legal guide, they open probate, advise the executor, prepare all those dense court filings, handle compliance, and coordinate the eventual closing. They're essentially the paperwork engine that makes sure this highly emotional process stays strictly legal. Then, out in the field, we have the real estate agent. They are your market sales specialist. Their job is to prepare pricing, market the home on the MLS, negotiate incoming offers, and coordinate appraisals to get the highest sale price possible in the real world. However, their final listing price always has to be rubber-stamped by the executor. And finally, the unsung hero of the whole transaction, the title company. As the neutral party, they're absolutely essential. They verify ownership via court order, handle the massive escrow funds, make sure any liens are paid, and officially record the deed transfer to the new buyer. They act as the neutral safety net securing the money.
And that brings us to Section 5. Who pays the bill?
Really, it all comes down to the ultimate question. Do heirs need to pay thousands in cash up front to sell the house? Look, when you're facing complex legal fees, court costs, and realtor commissions, this is usually the single biggest stressor that keeps grieving families awake at night.
Well, the incredibly reassuring answer is no. The estate itself is the funding source. Let me say that again. The estate controls the process and holds the funds. You generally do not have to empty your own personal savings to get an estate settled.
Let's look at exactly how those costs break down. Attorney fees are usually paid straight from the estate at closing. Court costs, those are pulled directly from the sale proceeds. Any out-of-pocket expenses from the executor are reimbursed by the estate account, and the realtor's commission comes directly out of the closing funds. So the big takeaway here is that as long as real estate is involved, no upfront money is required from the heirs. All the key players are compensated directly out of the home sale proceeds.
And that brings us to a final, pretty critical thought to leave you with today. Knowing that probate is a supervised court process that routinely takes a grueling 18 months, are your assets proactively structured today to protect your family from this maze tomorrow? I really hope this explainer has given you the clarity you need to reflect on your own estate plan. Go out there, seek professional legal guidance, take proactive action, and secure your legacy. Thanks so much for learning with us today.